idea of establishing a Muslim university gathered strength from year to year at the turn of the century, and by 1911, some funds were collected and a Muslim University Association was established for the purpose of establishing a teaching university at Aligarh. Long negotiations took place between the association and the government of India, which I had shown to your lordships, about how, under what circumstances, with what conditions, in what covenants. That is what, my lord, factually is seen, which eventually resulted in the establishment of Aligarh University in 1920 by the 1920 Act. It may be mentioned that before that, a large sum of money was collected by the association for the university, as the government of India had made it a condition that a rupee 30 lakh must be collected for university before it could be established. They didn't do it voluntarily. That was a condition for incorporating or establishing and incorporating as an act of parliament. Further, it seems that existing MAO college was made the basis of university and was made over to the authorities established by 1920 Act for the administration of university, along with the properties and funds attached to the college, the major part of which had been contributed by Muslims, though some contributions were made by other communities as well. It is necessary now to refer in some detail to the provisions of 1920 Act to see how Aligarh University came to be established. The long title of the 1920 Act is in these words: an act to establish and incorporate a teaching and residential Muslim university at Aligarh. The preamble says that it is expedient to establish and incorporate a teaching and residential Muslim university at Aligarh, and to dissolve the societies registered as so-and-so and so-and-so, and to transfer and vest in the said university all properties, and mark, my lord, and rights of the said societies and of the Muslim University Foundation Committee. The rights are surrendered by operation of law. It will be seen from this that the two earlier societies, one of which was connected with MAO College and the other had been formed for collecting funds for establishment of the university at Aligarh, were dissolved, and all their properties and rights and all the and also of the Muslim University Foundation Committee, which presumably collected funds for the proposed university, were transferred and vested in the university established by 1920 Act. Section 3 of the Act laid down that the first Chancellor, Pro-Chancellor and Vice-Chancellor shall be persons appointed in this behalf by a notification of the Governor-General in Council in the Gazette of India, and the persons specified in the schedule shall be the first members of the court, and they happen to be all Muslims. Please mark this, brother. The court says that they were not required to be, but they happen to be Muslims. Further, Section 3 constituted a body corporate by the name of Aligarh Muslim University, and this body corporate was to have perpetual succession and a common seal, and could sue and be sued by that name. Section 4 dissolved the MAO College and the Muslim University Association, and all property movable and immovable, and all rights, powers and privileges of the two said societies, and all property movable and immovable, and all rights, powers and privileges of Muslim Committee were transferred and vested in the Aligarh University, and were to be applied to the objects and purposes for which the Aligarh University was incorporated, not the objects of the original three institutes. All debts, liabilities and obligations of the said societies and committee were transferred to the university, which was made responsible for discharging and satisfying them. All references in any enactment to either of the societies or to the said committee were to be construed as reference to the university. It was further provided that any will, deed or other documents, whether made or executed before or after the commencement of 1920 Act, which contained any bequest, gift, etc., etc. Lord, kindly come down a little further, my lord. These provisions will show, Lord, fifth line from the bottom of that para, these provisions will show that three previous bodies legally came to an end, and everything that they possessed, but they were possessed of, was vested in the university as established by 1920 Act. Section 5 provides for the powers of the university, including the power to hold examinations and to grant and confers degrees and other academic distinctions. Section 6 is important. It laid down that degrees, diplomas, and other academic distinctions granted or conferred to or on persons by university shall be recognized. Then, my lord, section 7. Then, section 8, provided that university shall. Now, your lordships can skip this. There may not be. I'll read. Right? I'll read it. Section 7 provides for reserve funds, including the sums of rupees 30 lakhs. Section 8 provided that university shall.
Actually, Mr. Solicitor, now thereafter they are just reproducing the act.
Lord, I therefore wanted
You
to.
can now go to page 841, Placitum C. Last sentence.
My lord, before that, my lord, page 11, 841, my lord, yes, Placitum C. My lord, PDF page 11. Your lordships, we are on the same page.
Page 11.
These provisions clearly bring out that the final control in the matter was with the Lord Rector, who was the Governor General of India. Then comes section 14,
Now we
which
need
is
not read
again.
what section 14 says because we have read those steps. Now go to Placitum F. Their conclusions we will mark because before that they just reproduce the section and then the Placitum F.
This provision, though not so all pervasive as the provision in section 13 of the 20 Act shows, that the visiting board had also certain overriding powers in case the university authorities acted against the Act, statutes, and ordinances. There is no condition that Lord Rector and the members of the visiting board must belong to the Muslim community. Then, my lord, kindly come to, my lord, page 842, my lord, page 12 of PDF. My lord, select committee. My lord, this is important. It may be added here that the select committee, which went into the bill before the 1920 Act was passed, was not very happy about this proviso and observed, my lord, which proviso? Proviso to section 23 that all members of the court would be Muslims. They were not happy with that. And this is the finding of select committee. This is the observation of select committee. In reference to the constitution of the court, we have retained the provision that no person other than Muslim shall be a member thereof. We have done this as we understand that such a provision is in accordance with the preponderance of Muslim feeling, though some of us are by no means satisfied that such a provision is necessary. This was the genesis. My learned friend talks of genesis. This was the genesis, that what we are establishing is a secular university. But they said that we give in to their status, their request. Then, my lord, next is 23.2. Your lordships can consider skipping. Section 24 dealt with executive council.
The last sentence in the paragraph, the power of making statutes.
Well, I'll read them. I don't wish to. The way, my lord, petitioners read, I didn't want to read, my lord. They read, my lord. Anyway, my lord. Section 23.2, the court was to be supreme governing body of the university and would exercise all the powers of the university, not otherwise provided for by the 1920 Act, the statutes, the ordinances, and the regulations. So, residuary power. It was given the power to review the acts of executive and academic councils, save where such council had acted in accordance with powers conferred on them under the Act, the statute, or ordinances. So, if they have acted in accordance under those, court had no powers. The statute to direct that necessary action be taken by the executive or the academic council, as the case might be, on any recommendation of the Lord Rector. The power of making statutes was also conferred on the court, along with other powers necessary for functioning of the university. Please pause here. The real section says the power of amendment is subject to the approval. He can even, Governor General in Council can even completely reject. Section 24 dealt with the Executive Council, 25 with the Academic Council, and 26 with other authorities of the university. Section 27, 28. There is an important provision in section 28 which laid down that no new statute or amendment or repeal of an existing statute shall have any validity until it has been submitted through the visiting board, which may record its opinion thereon to the Governor General in Council and has been approved by the latter, who may sanction, disallow, or remit it for further consideration. This provision clearly shows that the final power of the administration of the university rested with the Governor General in Council. Section 29 dealt with so-and-so, so-and-so. Please come to, my lord, slightly above H. no new ordinance amendment or repeal of any existing ordinance shall have any validity until it has been submitted through the court so and so, who may sanction allowed. This again shows that even ordinances could not be made by the university without the approval of Governor General in Council. If any dispute arose between executive and the academic council as to which had the power to make the ordinance, an ordinance, either council could represent the matter to the visiting board, and the visiting board had to refer the same to a tribunal consisting of 3 honorable members. My lord, I'll skip. Come to my lord C. Section 32 provided for admission of students to the university, and subsection 4 thereof provided that university shall not, save with the previous sanction of the Governor General in Council, recognize for the purpose of admission to a course of study for a degree as equivalent to its own degree, any degree conferred by any other university, or as equivalent to intermediate examination of an Indian university, any examination conducted by any other authority. This shows that in the matter of admission, the university could not admit students of other institutions unless the Governor General in Council approved the degree or any other examination of the institutions other than Indian universities established by law. Lord, please allow me to pause here. Lord, the university functions at 2 levels. One is, Lord, supervisory, decision-making, policy-making function, which was not in the hands of minority. And second, on ground, the principal, vice principal, they will be giving admissions, etc. That they follow what is decided. That's not the administration. That is, Lord, complying with the administrative guidelines or directions issued. Lord, section 33, Lord, I'll come to F. Section 40 is important and laid down that if any difficulty arises with respect to the establishment of the university or any authority of the university, or in connection with the first meeting of any authority of the university, the Governor General in Council may by order make any appointment or do anything which appears to him necessary or expedient for the proper establishment of the university or any authority thereof, or for the first meeting of any authority of the university. Unbridled powers. This again shows the power of the Governor General in Council in the matter of establishment of the university. This brings us to end of sections of 1920 Act. There is nothing anywhere in any section of the Act which vests the administration of the university in the Muslim community. The fact that in proviso to section 23(1), it is provided that the court of the university shall consist only of Muslims does not necessarily mean that the administration of the university was vested or was intended to be vested in Muslim minority. If anything, some of the important provisions to which we have already referred show that final power in almost every matter of importance was in Lord Rector, who was the Governor General, or in Governor General in Council, or Academic Council, I'll add, because I have shown the statutory provisions. Such were the provisions of 1920 Act. They continued in force in 1951 without any substantial amendment. In 51, the 1951 Act was passed. It made certain changes in 20 Act mainly on account of coming into force of the Constitution. We shall refer only to such changes as are material for our purposes. The first change, my lord, I can skip that, my lord. F, please come to classitum F. It was necessary to delete section 9 as otherwise the university might have lost the grant which was given to it by the Government of India. Further, section 8 of the 1920 Act was amended as the new section provided that the university shall be open to persons of either sex and of whatever race, creed, caste or class, and it shall not be lawful for the university to adopt or impose on any person any test whatsoever, etc., etc. My lord. Lord, kindly come to, my lord, last 3 lines. Ordinances to those we have consented to receive it. Clearly, section 9 was deleted and section 8 was amended in this manner to bring the law in conformity with the provisions of the Constitution and for the benefit of the university, so that it could continue to receive aid from the government. Some amendment was also made in section 13 in view of the changed constitutional setup, and in place of Lord Rector, the university was to have a visitor. Section 14 was also amended and the power of visiting board was conferred on the visitor by addition to a new subsection 6. The next substantial change was that the provisos to section 23(1), which required that all members of the court would only be Muslims. My lord, I can, my lord, skip that.
Yes.
So please come to, my lord, placitum E. It is not our function in the present petition to consider the policy underlying the amendment made by the 1965 Act, nor
Because it remains the supreme government.
I'll read it fully, my lord. It will thus be seen by virtue of 1951 Act, non-Muslims could also be members of the court. My lord, correct, my lord. Yes, I am reading the full paragraph, sir.
Thank you.
But the court still remained the supreme governing body of the university as provided by.
This is what is highlighted by them. Because once you hold that the court was the supreme governing body,
Yes, my lord.
then, and the pre-1951 position was that they were all Muslims. That's the contradiction pointed out in the judgment.
Yes, my lord.
Because here they clearly say the court will still be the supreme governing body of the institution. One, just one. You said there's a distinction between policy and administration. I recorded it specific. What you highlighted was policy is the equivalent to administration. That will be slightly debatable. But here,
Would
the
your
contradiction-
lordships-
just one.
I'm sorry.
Here, the contradiction which is pointed out is the judgment refers to several provisions, then it holds that court is not the supreme administrative body. And here in paragraph over here, they themselves contradict and say court is still maintain the supreme governing body of the court, of the institution.
Lord,
That's where the contradiction is.
Lord, would your lordships allow me to show section 23?
I'm just highlighting that.
No, my lord, at this juncture, it would be relevant, my lord. The statement which is made, but let us read the section as amended in 51, my lord. That's the answer, my lord. As amended, my lord. The court, and my lord, in 65, it even stopped being supreme governing body, but please see, the court shall, my lord, your lordships can have the chart, my lord, for time being, for my satisfaction, my lord. Supreme body with residuary powers. Lord, words don't confer powers. It is the real powers which have to flow from the statute.
Let's see 23.
Lord, 23 as amended by 51 Act. Because Aziz Basha is referring to 51 Act. Therefore, I am taking 51 Act. Because 65 even did away with, my lord, even that.
Let's read 23.
23-2.
Yes, let's see, read original 23.
Your lordship would like to read the original?
Yes.
Yes. My lord, your lordships can read this because original is retained.
No,
Whatever
just-
is
Let's
added-
let's have 23. It's there in your chart, sir.
the second column.
Yes, let's read the first one and the second one.
Oh, we'll read the both. The court shall be the supreme governing body of the university and shall exercise all the powers of the university not otherwise provided for by
No,
this
there are
act.
two things now. Just read part one also. The court shall consist of the chancellor, pro-vice chancellor, vice chancellor for the time being, and such other persons as may be specified in the statutes, provided that no person other than the Muslim will be a member thereof.
Correct.
Now, will it also mean, the proviso will also mean that the chancellor, pro-vice chancellor,
No.
and vice chancellor should be
It-
Muslims?
It cannot mean. It cannot.
1 minute, please. No,
Only a minute.
That's
Only a
a
minute.
question to the other side, why? Will it mean that the
Lord, they can-
chancellor, pro-vice chancellor and the vice chancellor will be Muslim? Because if they are members of the court and the proviso say they have to be, all members of the court will be Muslim, can it be impliedly said that
No,
the
Lord,
chancellor, vice
we
chancellor?
had examined this, my lord. The real intent is that whoever they are, happen to be Muslim, happen to be non-Muslims, they would ex officio become members of the court.
Okay, we have understood. Now come to page, paragraph
Because, my
2.
lord, thereafter, whenever there is an amendment, this has not undergone change.
That's correct.
Yes.
But there is an amendment which, no, this portion that they shall be Muslim thereof has been deleted.
That is deleted.
1951.
That has been deleted in.
1951.
Yes, yes.
So that's a big change. But
Yes.
now come to this part, paragraph 2.
Two, my lord, what was the
Just
power?
Yes, I've got, just listen.
I'll
The
read.
court shall
Well,
be
I-
the supreme
well,
govern,
did-
just one,
yes.
The court shall be the supreme governing body of the university. That's part one.
Correct.
And shall exercise powers of the university is not exercisable.
Not
otherwise
otherwise
provided. So there are two parts to it. One is it's a supreme governing body. That's part one. The second is it shall exercise such other have the power to exercise such other powers which are not specified by the statute, ordinances, or regulations.
So, right, the miscellaneous, what do we call?
No, it's not.
Residuary powers.
That's part two. Part one is it being the supreme governing body.
Thereafter, please read, Supreme Governing Body, and shall exercise all the powers of the university not otherwise provided for by this act, the statute, the ordinances, and the regulations. It shall have power to review the acts of executive and academic council, but which powers? Review of what? Save where such councils have acted in accordance with powers conferred on them under this act, the statute, and the ordinances. If something else happens, they can review the functioning or powers exercised by these three bodies. So here also they have residuary power. Then, and direct that necessary action be taken by the executive or the academic council as the case may be on any recommendations of the Lord Rector. Again, my lord, their recommendation is not binding. It goes via Lord Rector, and if the Lord Rector finds that yes, this is a power exercised by academic council or executive council, which is not their part of the power under the statute or ordinance, and the court has something to say, then, my lord, their recommendation will go. So, my lord, it's a misnomer to say that it is a supreme governing body. Supreme governing body, yes, for anything other than what is provided for under the statute. Suppose the statute confers absolute power on executive council about admissions. Then, my lord, this body will, the court will not come into the picture. If the ordinance provides supreme power of, say, rustication of students or conferment of degrees or the quality of examination, that would be decided by those 15 or 16 people of executive council or academic council, not by 180 people, my lord, sitting together.
The court is supreme only in respect of those powers which are not expressly or by implication conferred on other authorities.
Yes, my lord. Therefore residuary, that's my respectful submission.
That is what the provision says.
That's the, my lord, interpretation. Now, my lord, in 51, my lord, your lordship said, my lord, the second column, this proviso is deleted, provided that no person other than Muslim shall be a member thereof, and this power is also taken away, my lord, on the next page, and direct that necessary action be taken by executive or the academic council, as the case may be, on any recommendation of the Lord Rector. My lord, this is taken away. Otherwise, the residuary powers not vested elsewhere under the statutes or ordinance is remain.
What 12D may be read. The last line, D.
Last line of?
Yeah. The power is the.
Correct, my lord. I am on the act, my lord, right now. My lord, here when your lordships have this, my lord, can your lordships also see 65 amendment, because Basha considered that also.
Yes. The argument on 65 amendment is, it's because of the peculiar situation which had come about in 65.
Yes.
It was a little disturbing situation.
Yes.
And therefore,
think,
the amendment was a
There were
temporary.
several issues, my lord, which we may not go into.
I tried to find out what are the reasons.
Aliyavar Jung was the vice chancellor, if my research is correct, very eminent diplomat, and he was so brutally attacked.
Became, governor of Maharashtra.
He was governor of Maharashtra also, my lord, and he was an ambassador in several important countries, and he was a very diplomat of repute. He was requested by Justice Chagla to go there and handle the situation, because there were several things happening which I am not right now going to, my lord, discuss. It's not in good taste. He was so brutally attacked that he had about 20 wounds on the vital parts of his body, and he barely survived.
But their argument on that is that these were temporary in nature.
My lord, it
Tide
continued.
over the problem at that time.
My lord, kindly see thereafter 72. 72 is 65, my lord, please see. 65, my lord, they make it only advisory. But, my lord,
Their argument on that will be that if one holds that it is a minority institution in terms of Article 30, then these amendments may be wrong, may be contrary to the law.
then, my lord, what can be wrong?
Then those amendments are contrary to Article 30 because they withdraw. That's a separate argument. We understand
My
that.
lord, they have
That
not,
your argument that it is not a minority institution, stand not
my lord,
support that.
that has attained finality. My lord, that amendment on facts, your
Once
lordship
we
would
examine-
then be
once-
requested to sit in appeal. If your lordships have to, my lord, there are some finding of facts also recorded. If your lordships were to be requested to declare those amendments to be unconstitutional after, my lord, almost 60 years, I'm not on delay, and that too without putting any challenge, Lord, then it would be exercising
No, no,
the power of.
Basha, the challenge was there.
Yes.
Challenge was there.
Correct, my lord.
Basha, the challenge.
But kindly see the reference order. Reference order says there is a question frame. Reference order, my lord, unfortunately is not shown to your lordships. It's not that you entirely,
Reference order was shown to us.
that
There are two
reconsider
reference
Basha, entirely reconsider and take a different view. That's not, my lord, the reference. Reference is that there was a reference made to 11 judges bench in TMFI. What can be the indicia for deciding that this institution is a minority institution? That was not answered by TMFI. And therefore, the court refers it, that Basha has something to do and impugn order in those appeals referred to Basha. Therefore, Basha is here. Not that the court is requested to take a different view sitting in appeal over Basha. I'm sorry, I'm better.
I'm right to address.
Yes, my lord, just for want of better expression, what I'm saying. Well, let me, my lord, go further. It will thus be seen that by virtue, my lord, I have read that, my lord. It is remarkable that though the proviso to section 23(1) was deleted as far back as 1951, there was no challenge to 51 Act till after Ordinance 2 of 65 was passed. My lord, 51 is now, my lord, what, 74 years away. Back, my lord. The reason for this might be that there was practically no substantial change in the administrative setup of 1920 Act, and it was only when a drastic change was made by the ordinance of 1965 followed by 65 Act that challenge was made not only to the 65 Act but also to this 51 Act, insofar as it did away with the proviso to section 23(1). It is not our function in the present petition to consider the policy underlying the amendments made in the 1965 Act, nor do we propose to go into the merits of the amendments made by 1965 Act. We are in the present petition concerned only with the constitutionality of the provisions of 1965 Act. If the provisions are constitutional, they were within the legislative competence. This brings us to the changes made in 65 Act, which have occasioned the present challenge. The main amendment in 65 Act was in section 23 with respect to the composition and powers of the court of the university. My lord, this I can skip, my lord, with your lordship's permission, unless other side wants me to reread, because it narrates, my lord, what is 65 amendment. Please come to, my lord, 846 E, Placitum E. This was the contention. The contention of the petitioners is that by these drastic amendments in 1965, the Muslim minority was deprived of the right to administer Aligarh University, and that this deprivation was in violation of Article 30. Under Article 31, all minorities, whether based on religion or language, shall have the right to establish. My lord, that also, my lord, your lordships can, or my lord, I may.
The next line, please.
I'll read, my
Mr.
lord, whatever
Solicitor, the next paragraph, portions of it have been quoted in the referral order.
Yes, ma'am.
And that is what is doubted by the bench of 3 judges. Whether establish and administer is to be read as establish or administer.
That's not their argument.
No, this is what the.
Yes, your lordships are right. But my lord, we are going on a footing that they have also said that end is end. It is not disjunctive. But that's the only reference. But that I didn't hear them argue that should be either established or
No, I think
administered.
the arguments have proceeded on the basis that establish and administer means that both conditions have to be.
Must coexist. Yes, yes, yes.
The reference order specifically referring to all previous judgments insists on the fact that whether it's conjunctive or disjunctive. And that's why Yashpal and the NMEIC Act is also referred to, because the words established or incorporate were there. So one of our arguments is going to be the scope of reference was only on the issue of being conjunctive or disjunctive. The other issues of Bhasha, whether administered, established, or the facts of the case were never referred to. These internal contradictions are now being argued. They are not the subject matter of reference ever.
Lord, kindly
16F may be read, my lord, just after the first paragraph.
16F. my
You
lord.
shall proceed on the assumption.
Where is it?
Sir.
We shall proceed on the assumption in the present petitions that Muslims are a minority based on religion. No, nobody disputes that, my lord. Nobody disputes that religion. What then is the scope of Article 30, Sub-Article 1, and what exactly is the right conferred therein on the religious minorities? It is to our mind quite clear that 31 postulates that the religious community will have the right to establish and administer educational institution of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. So kindly permit me to pause here. Lord, my respectful submission is going to be that if at all your lordships are called upon to reinterpret Article 30 in facts which are already decided, the choice will be choice to establish and administer, not the manner and method of establishment. That only Parliament can prescribe. That you decide, you make a university by an act of Parliament, you register as a society under the Registration Act, but that's a separate issue. Let me complete this. Lord, I don't wish to, Lord, deviate. Establish and administer educational institutions of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. An argument has been raised to the effect that even though religious minority may not have established the educational institution, it will have the right to administer it if by some process it had been administered by the same before the Constitution came into force. Now, my lord, having found a roadblock about establishment, they say, all right, but we were administering. Have a right to administer it if by some so and so. We are not prepared to accept this argument. The article, in our opinion, clearly shows that the minority will have the right to administer educational institutions of their choice, provided they have established them, but not otherwise. The article cannot be read to mean that even if the educational institution has been established by someone else, any religious minority would have the right to administer it because for some reason or the other, it might have been administering it before the Constitution came into force. The words establish and administer in article must be read conjunctively, and so read, it gives the right to the minority to administer an educational institution provided it has been established by it. In this connection, our attention was drawn in Kerala Education Bill, where it is argued this court had held that the majority can administer an educational institution even though it might not have established it. Kerala doesn't say this. I'm going to read 2 paragraphs from Kerala. It's a 7-judge bench. In that case, an argument was raised that under Article 30, Sub-Article 1, protection was given only to educational institutions established after the Constitution came into force. That argument was turned down by this court for the obvious reason that if the interpretation was given to Article 31, it would be robbed of much of its content. But that case, in our opinion, did not lay down that the words establish and administer in Article 30, Sub-Article 1 should be read disjunctively, so that though a minority might not have established an educational institution, it had the right to administer it. It is true that at page 1062, the court spoke of Article 30, Sub-Article 1, giving 2 rights to a minority, that is, one, to establish, and two, to administer. But that was said only in the context of meeting the argument that educational institutions established by minorities before the constitution came into force did not have the protection of Article 30, Subarticle 1. We are of the opinion that nothing in that case justifies the contention raised on behalf of petitioners that minorities would have the right to administer an educational institution even though the institution may not have been established by them. The two words in Article 30 sub 1 must be read together, and so read, article gives the right to the minority to administer institutions established by it. If the educational institution has not been established by a minority, it cannot claim the right to administer it under Article 31. We have therefore to consider whether Aligarh University was established by the Muslim minority, and if it was so established, the minority would certainly have the right to administer it. Well, that was not argued that it is disjunctive. So we are also proceeding on that ground basis. Then, my lord, court quotes the Dargah Committee Ajmer case. My lord, this is where I say, when you surrender your right. I'll read, my lord, H. My lord, this is also 5-judge bench judgment in Dargah Committee Ajmer. If the right to administer the property is never vested in the denomination or had been validly surrendered by it, or had otherwise been effectively and irretrievably lost to it, Article 26 cannot be successfully invoked. Now, my lord Aziz Basha, the bench says, we shall have to examine closely what happened in 1920 when the 1920 Act was passed to decide, firstly, whether in the face of the Act it could be said that Aligarh University was established by the Muslim minority. Secondly, whether the right to administer it ever vested in the minority. And thirdly, please mark this, even if the right to administer some properties that came to the university vested in the minority before the establishment of Aligarh University, whether it had been surrendered when the Aligarh University came to be established. Well, Lord, this is a question of fact the court poses for itself and answers as of fact that yes, you have surrendered. Before we do so, we should like to say that words educational institution are of very wide import and would include university also. This was not disputed on behalf of Union of India, and therefore it may be accepted. Thereafter, my lord, I'll come to D, class item D. There is a good deal in common between educational institutions which are not universities and those which are universities. Both, I'm sorry, my lord, just before D, my lord, I'm sorry. The position with respect to establishment of universities before the constitution came into force in 1950 was this: there was no law in India which prohibited any private individual or body from establishing a university, and it was therefore open to a private individual or body to establish university. My lord, therefore, my lord, I gave the history how the regime change took place. Till 56, anyone can establish university. MAO could have done it without, my lord, surrendering their rights before the parliament. There is a good deal in common between educational institutions which are not universities and those which are universities. Both teach students and both have teachers for the purpose. But what distinguishes a university from any other educational institution is that a university grants degrees of its own while other educational institutions cannot. It is this granting of degrees by a university which distinguishes it from the ordinary run of educational institutions. See St. David College, etc. Thus, in law, in India, there was no prohibition against establishment of universities by private individuals or bodies, and if any university was so established, it must of necessity be granting degrees before it could be called a university. But though such a university might be granting degrees, it did not follow that the government of the country was bound to recognize those degrees. Britishers would not recognize those degrees. It was not recognized for government service. Therefore, at the cost of repetition, I say many universities came without an act of British Parliament. and they produce one of the finest alumni. I have the list, my lord, but that's not the relevant thing, my lord. I'm not going into it. As a matter of fact, as the law stood up to the time the constitution came into force, the government was not bound to recognize degrees of universities established by private individuals or bodies, and generally speaking, the government only recognized degrees of universities established by it by law. No private individual or body could before 1950 insist that degrees of any university established by him or it must be recognized by the government. Such recognition depended upon the will of the government, generally expressed through the statute. The importance of the recognition of government in matters of this kind cannot be minimized. This position continued even after the constitution came into force. It was only in 1956 that by subsection 1 of section 22, the University Grants Commission Act, it was laid down that the right of conferring or granting degrees shall be exercised only by a university established or incorporated by or under a central act. Lord, please mark this word, established or incorporated. Even if it is only incorporated, it is by the statute, my lord. So, my lord, I am on that amendment of 81. Deemed central act, a provincial act or a state act or an institution deemed to be university under section 3 or an institution specially empowered by an act of parliament to confer or grant degrees. Subsection 2 thereof further provided that save as provided in subsection 1, no person or authority shall confer or grant or hold himself or itself as entitled to confer or grant any degree. Section 23 further prohibited the use of the word university by an educational institution unless it is established by law. It was only thereafter that no private individual or body could grant a degree in India. The court now refers to earlier, that earlier there was no such prohibition. Therefore, it was possible for the Muslim minority to establish a university before the constitution came into force, though the degrees conferred by such a university were not bound to be recognized by the government. This is the ratio, not that once the ratio as propounded before your lordship is that once it is established by an act, you cease to be a minority, and now the act requires, UGC Act requires an act, and therefore there can be no minority institution. No. Even after UGC Act, there are minority institutions. I have given examples how they are created. Here it was a sui generis case that you could have done what others did. Then there was nothing in 1920 to prevent the Muslim minority, if it so chose, to establish a university. But if it did so, the degrees of such university were not bound to be recognized by the government. It may be that in absence of recognition of degrees granted by a university, it may not have attracted many students. And that is why we find that before the constitution came into force, most of the universities in India were established by legislation. The Aligarh University was also in the same way established by legislation, and it provided under section 6 of the 1920 Act that the degrees, diplomas and other academic distinctions granted or conferred to or on persons by the university shall be recognized by the government, as are the corresponding degrees, diplomas and other academic distinctions, etc. It is clear, therefore, that even though Muslim minority could have established at Aligarh in 1920 a university, it could not insist that degrees granted by such a university should be recognized by the government. Therefore, when the Aligarh University was established in 1920 and by section 6, its degrees were recognized by the government, an institution was brought into existence which could not be brought into existence by any private individual or body, for such individual or body could not insist upon recognition of degrees conferred by any university established by it. The enactment of section 6 in 1920 Act is a very important circumstance which shows that the Aligarh University, when it came to be established in 1920, was not established by Muslim minority, for the minority could not insist on the recognition by government of the degrees conferred by any university established by it. My lord, Vishwa Bharati University was a private university and was recognized after UGC Act came into force. Gujarat Vidyapith was a private university granting degrees, several legal and other luminaries as their alumni. They got the status of university after UGC Act. That is what Aziz Basha says. It is true, as it is clear from 1920 Act, that the nucleus of the Aligarh University was the MAO College, which was still then a teaching institution under the Allahabad University. The conversion of that college, if may use that expression, I'm sorry. Lord, the court is very conscious of using the word conversion, because it died. The earlier body died, and a new body comes into effect, and therefore, my lord, the court says, if we may use this loosely, my lord, court uses, if the conversion of that college, if we may use the expression, into a university was, however, not by Muslim minority, it took place by virtue of 1920 Act, which was passed by the central legislature. There was no Aligarh University existing till 1920 Act was passed. It was brought into being by the 1920 Act and must therefore be held to have been established by the central legislature, which by passing the 1920 Act incorporated it. The fact that it was based on MAO College would make no difference to the question as to who established the Aligarh University. The answer to our mind as to who established the Aligarh University is clear, and that is that it was the central legislature by enacting the act that established the said university. As we have said already, the Muslim minority could not establish a university whose degrees were bound to be recognized by government as provided by Section Act. That one circumstance, along with the fact that without 1920 Act, the university in the form that it had could not come into existence, shows clearly that the Aligarh University, when it came into existence in 1920, was established by central legislature. It may be that the 20 Act was passed as a result of efforts of Muslim minority, but that does not mean that Aligarh University, when it came into being under our 20 Act, was established by Lord, then your lordships can, unless the other side wants, my lord. My lord, kindly come to page 21, my lord, 851. My lord, F, my lord, the paragraph starting with F. I'm sorry, my lord, just below D. Just below D. We are of the opinion, my lord.
The court has proceeded on the foundation that MAO College and the Muslim University Association were institutions founded by the Muslim minority. They say that both the MAO College and the Muslim University Foundation, they were societies, they were founded by the Muslim minority.
Correct.
Second, they said that MAO College furnished the nucleus for Aligarh Muslim University. There are both these findings which we find. The first, which I said at the bottom of page 22, and the second at the bottom of page 19. But they say that because the establishment of the university was by an act of the legislature, therefore, it's not an institution which is established by the Muslim minority. And to